Morning, everyone. I'm going to call to order the State of Rhode Island Coastal Resources Management Council's semi-monthly meeting to order. Today is Tuesday, May 13, 2025. I would ask that the record reflect the council members that are present here this evening, as well as staff members as well. Our first matter on the agenda will be approval of the minutes of the previous meeting, that being April 22, 2025. I know Lisa has disseminated them. Has the council had an opportunity to review them? And if so, are they in a posture to motion approval and acceptance?
I'll make a motion to approve and say thank you to Lisa because it was not an easy meeting to capture. So thank you for that.
The motion has been made by Member Flynn.
Second.
Motion made and seconded. All in favor, say aye.
Aye.
Aye. Anyone opposed? Motion carries. Subcommittee reports, Director Willis.
There are no subcommittee reports tonight, Mr. Chair.
Staff reports.
Yes, thank you, Mr. Chair. Just a couple of items. I met recently with a board member of the Rhode Island Builders Association, who with his director and other members would like to reinstitute a CRMC Builders Association training program. We've had that in the past, well over 10, 15 years ago, where we meet with the builders at least once or twice a year, especially for some of their newer members, to get an understanding of what CRMC's regulatory program is all about relative to the builders community. As well as allowing their members to get continuing education credits for those types of meetings. So we are creating a one-day, basically a half a day education series for the Builders Association that'll occur sometime in July. We're looking forward to doing that and reestablishing that relationship with REBA. Similarly, the Environmental Business Council asked us to attend their leadership presentation in July, where they too want to provide to their members basically everything that CRMC is up to these days. So from basic permitting issues to dredging issues to aquaculture to wind farms, they want to know all about that. That too will be held in July. We'll meet with them. And that's a regular thing that we do with the Environmental Business Council. We meet with them at least once, twice a year to introduce not only these issues, bring them up to speed on that, but also so that they can meet staff that they interact with in their various disciplines. Lastly, I want to, probably should have led with the bad news first, right, rather than the good news. The bad news is that we had an award from NOAA, our federal partner, to do some additional public access to the shore work for underserved communities, getting them down to the shore in a better representative way. Looking at some of those access ways from a resilience standpoint. However, the administration has pulled back that award for us to undertake, and we will not be able to accomplish that. Unfortunately, it was phase 2 of a 2-part project, which we had already finished phase 1. We are working with our congressional delegation, the 2 senators and the 2 congressmen, who are very receptive in pushing back to the administration to try to get those funds back to the agency, but it's quite a bit of money. It was not going to directly support our staff, but it was going to support other agencies' staff, as well as the university staff, and as well as the municipalities to help establish and better create opportunities for the public to access the shore. So we're very grateful to work with our congressional delegation to do what we can to try to get that money reestablished. That's it, Mr. Chair.
Any questions of Director Willis? All right. Next matter will be confirmation of Fishermen's Advisory Board member Heather Lowe. Is Heather here?
She is not.
Okay. Do you want to report anything on that?
Just what you have in your agenda package, council members. As we mentioned in the past, we are basically having a rolling enrollment, if you want to think of it that way. It's not really a pure enrollment, but we solicit for volunteers to become part of our Fishermen's Advisory Committee board. If you'll remember, that board helps staff understand some of the issues associated with offshore wind development projects, from a fishing community perspective so that we can better inform and negotiate with the developers of offshore wind projects to minimize, if not eliminate, the impacts to the fishing industry. Heather has volunteered to come on board. We vetted her, and her qualifications are in your agenda package, and just a brief description of those are on the agenda item tonight. So I think she speaks for herself. We're looking forward to have her on board if you agree and ratify her.
Any questions of Director Willis on this matter? I would entertain a motion to seat Heather Lowe as a member of the Fishermen's Advisory Board.
I'll make the motion to seat Heather Lowe. She looks very qualified as a member of the Fishermen's Advisory Board.
The motion has been made by Ms. Reynolds. Is there a second? Seconded by Mr. Rossellino. Any discussion? Hold the council. Mr. Flynn.
Aye.
Mr. Izzy.
Aye.
Mr. Rossellino.
Aye.
Mr. Gagnon.
Aye.
Ms. Reynolds.
Aye.
I too, Raymond Coyer, vote aye. Brings us to our applications, which have been out to notice and are before the council for review and action. The first one being 2024-06-087 William J. Rowe Trust. It's an application to construct and maintain a new 1,727 square foot single family home, the driveway, stormwater to connect to city utilities, converting the existing 786 square foot historic John Tripp House into a guest house. The proposed new dwelling requires a variance to section 650-RICR-20-00-1.11 parentheses C parentheses 3 parentheses B, requiring a 50-foot buffer zone. The project additionally requires a variance to section 1.1.9, which requires a 75-foot construction setback, parentheses 25 feet beyond the buffer zone, close parentheses, period. The setback proposed will be 10 feet at its smallest, and the buffer will be 15 feet at its smallest. It's located at plat 12, lot 46, at 88 Washington Street, Newport, Rhode Island. And at this point, I'm going to turn it over to Attorney Hartman to report on a correspondence that he had received as it relates to this matter.
Thank you, Mr. Chair. Last week, legal counsel and the CRMC staff received a stipulation from the applicant in this matter, the trust and the objectors, requesting that the matter that's scheduled for tonight be sent to a subcommittee. And the stipulation further indicates that the applicant and the objectors will not be providing evidence tonight in support of their substantive positions as a result of that agreement that they're requesting to send this to a subcommittee.
Are the parties to that document present this evening?
Hi, good evening, Mr. Chair.
Hi.
Josh Parks. I represent several neighbor objectors.
And Jay Lynch representing the applicant.
Okay, anything to add which been reported by Attorney Hartman?
Not for me, Your Honor. I had submitted, received several letters from me in this matter. I don't know if the council's had a chance to review. The most recent one set forth my reading of CRMC regulations and given the findings in the staff report as to why this matter is appropriate for a subcommittee. But I think given the stipulation before you, I think, you know, I'll just rest on that.
Okay,
I have nothing further to add.
all right.
Mr. Chair,
Yes.
if I may add, I would tend to agree with the position of council in that our management procedures set up a circumstance where a matter that is not necessarily received as substantive objection can still be sent to subcommittee if there's a vote of 4 or more members of the council. And this is specifically 650 TAC RICR TAC 10 TAC 00 TAC 1.5.3A. And that states a subcommittee hearing shall be required when a substantive objection is received from any party, or when requested by members, a vote of 4 or more of the Coastal Resources Management Council. So in my view, Mr. Chair, if this is at the council's pleasure, whether they want to follow the filed stipulation of legal counsel, both the applicants and the objectors.
And it's your opinion based on a review of the file, the contents contained within the file, and the stipulation that was presented this evening, that we are within our authority to send it to subcommittee on a vote of 4 sitting members this evening, correct?
That's correct, Mr. Chair, and I'd add that a vote of 4 or more would not necessarily say whether or not the case is a contested case or that a substantive objection has been filed. It's just simply a procedural matter of sending this to a subcommittee without ruling on that.
Okay. Any questions of Attorney Hartman at this point from council members as it relates to what he's reported and the stipulation that he's referenced this evening? Mr. Flynn.
Question, given that both attorneys have requested this, what would be the rationale for not doing it?
Well, Mr. Flynn, the rationale would, I think you could probably find it in the staff report. The staff is indicating that, and Jeff, correct me if I'm wrong, that they don't believe that this matter is a contested case.
That's correct.
And if you
I would just add that staff has looked at all the objections, and in their opinion, in reviewing those objections against the applicant's request, the evidence weighed, they don't believe that the objections rise to a substantive objection, which at that point, if the council agreed with that, the matter would not be contested. If the council did not agree with that, maybe it would be. So that argument would have to be settled prior to any discussion of the merits of the case.
So add to that, again, typically of matters that there's not a substantive objection filed and they're not set down to be a contested case, typically the council would just hear them. However, it's peculiar circumstances or special circumstances, such as a request by the parties jointly to receive a subcommittee hearing, the council has discretion to send it to a subcommittee, even if the staff recommendation is that it's not necessarily a contested matter.
Okay.
Based upon what's been said, is the council in a position to make a motion to send it to subcommittee?
I'll make a motion to refer the matter to the subcommittee.
All right. A motion has been made by Mr. Flynn. Is there a second?
Second.
Seconded by Mr. Russolino. Any discussion? Hearing none, I will poll the council. Mr. Flynn?
Aye.
Mr. Izzy?
Aye.
Mr. Russolino?
Aye.
Mr. Gagnon?
Aye.
Ms. Reynolds?
Aye.
I too, Raymond Boyer, vote aye. So the matter will be referred to subcommittee.
Thank you. If I
Thank you.
may just place one kind of statement on the record. I would just refer the council to the staff report as regarding whether or not the objections are substantive. It's not paginated, but in the staff report, when they discuss section 1.1.6G, to be considered a contested case, objections must meet one or more of the criteria set forth therein. Subparagraph B points out that the proposal does not meet the policies, prerequisites, and standards, which is through a variance. Therefore, the council may deem that these objections are substantive. So I would just, reserve on our ability to contend that the objections are in fact substantive. I understand.
That's fine. We didn't even address that
Committee
point
anyway.
at this point.
Right, thank you.
All right, thank you.
Very much.
Bring us to our next matter, 2023-08-084 TSL, LLC. It's a project, is a marina expansion, which includes 5 additional new pilings, an additional new ramp, and a wave fence. The marina expansion will be an increase of 2,500 square feet to the existing marina. The purpose of this expansion is to provide space for a new pool boat as an amenity to the existing onshore hotel business. It's located at Plat 9, Lot 50, 267 Thames Street, Bristol, Rhode Island. The party is the applicant ready on this particular one. Evening, Council.
Everything is ready.
And just identify yourself for the record.
For Seth Handy from Handy Law for TSL LLC. And I'm here.
I'm Ron Blanchard with, from Site Engineering.
All right, I believe Justin, you have this one?
Well, Mr. Chair, if I may address some legal issues that arose last week with regard to this case before
Okay.
staff presents their report. So last week, the objectors in this matter, this is Stone Harbor Condominium Association, they submitted objections to CRMC staff over the course of their review of the matter. Stone Harbor Condominium Association filed a lawsuit in Superior Court. This is PC TAC 2025 TAC 02360. The complaint made a claim under declaratory judgment, and we're requesting actually a temporary restraining order with mandatory injunctive relief. Now, what this means is that Stone Harbor was filing a lawsuit against both the applicant and CRMC, requesting that CRMC take specific action. And in this particular instance, they were requesting that the court command CRMC to send the applicant's application to a subcommittee after determining that the matter is a contested case. The Superior Court took the TRO into a hearing, and arguments were presented by Stone Harbor Condominium, by TSL LLC, and by the CRMC on whether a TRO, a temporary restraining order, should be granted. The court looked at the temporary or the preliminary injunction standards, the TRO standards under Gabriel v. Willis. This is a case in Supreme Court, 326 Atlantic 3rd, 172. And the court analyzed the factors set out in that case for whether a preliminary injunction should be granted. And those factors are as follow: whether the moving party, that's the Stone Harbor Condominium Associates, has a reasonable likelihood of success on the merits. That's number one. Number two, will Stone Harbor Associates suffer irreparable harm without the requested injunctive relief? Three, has the balance of the equities, including the possible hardships to each party and to the public interest, tip in Stone Harbor's favor? And four, has Stone Harbor shown that the issuance of a preliminary injunction will preserve the status quo? So the idea with Stone Harbor Condominium's argument before the Supreme Court, or before the Superior Court rather, was that if CRMC doesn't send this case to a subcommittee, they will face a harm because of that. The Superior Court Justice McBurney looked at the filings and took into consideration the arguments. And what he determined is that a TRO was not appropriate at that time and that he was not going to command CRMC to send this matter to a subcommittee. His reasoning was that CRMC has not had the chance to determine whether or not a substantive objection has been filed, thereby making this a contested case, which would be required to be sent to a subcommittee or a hearing officer. Justice McBurney principally looked at the fact that the council, this matter hasn't been before you yet, so you haven't had the opportunity to determine whether this is a contested case or not. And he actually applied that in analyzing the 4 factors. And thus he denied the request for relief. However, because of the litigation, it does raise the question, have substantive objections been filed in this case? And if so, must it be sent to a subcommittee or hearing officer? As the regulations do require that contested cases after receiving a substantive objection are supposed to be sent to a subcommittee or hearing officer. So before we can get into the beef of this or the meat of this case, it would be my recommendation that the council look into whether or not the objections filed are in fact substantive, thus requiring a heightened level of review. And I think that this would be appropriately done by hearing from the objectors, having the applicant then respond to the objectors, and then hearing from CRMC staff as to whether the objectors did in fact submit evidence that demonstrates they have filed a substantive objection requiring a subcommittee hearing.
Okay. And just because we had a case prior to this one, am I correct? There's no stipulation by parties to have this go to a subcommittee, correct?
That's my understanding, Mr. Chair.
Okay. I'll defer to you in which order. Traditionally, we will hear from staff. What is it, your recommendation that we hear from objectors?
Well, I think we can hear from staff first, Mr. Chair. I think that would be perfectly appropriate.
Okay.
But I think it would be also be appropriate to have staff respond to whatever they might hear from applicants and objectors.
Okay. And Justin, you have this correct?
That's correct.
Okay. Your report.
So before I start, I just want to clarify, I was planning for the report to respond to all objections. Do you wish for me to respond to substantive first, or?
I think we need to have you respond to the position that the objections rise to a substantive matter or not.
Okay. Yeah. Thank you.
And they've submitted them.
Okay.
They've submitted the objections.
So staff received comments from the public and reviewed any potential substantive objections under section 1.1.6G. So we define substantive objections are one or more of the following: a direct threat of loss of property of the objector at the site in question. Staff do not see any evidence of direct loss of property. The proposed marine expansion is complete with the applicant's property extensions. Direct evidence of the proposed alteration activity does not meet all the policies, prerequisites, or standards contained in the proposed site plan document. Staff has reviewed the application completely with all necessary information for staff to make informed evaluation recommendation.
You have to slow down a little bit.
Oh, I'm sorry.
I can write it down.
Staff views this application as complete with all necessary information for staff to make an informed evaluation and recommendation to the council. Objections were raised about insufficient material. Staff determined such material as unnecessary, as the pool boat isn't a build or a structure, rather meets the definition of a boat and was evaluated as such. Evidence is presented under 1.1.6 GC. Evidence presented which demonstrates the proposed activity or alteration has potential for significant adverse impacts and one or more of the following descriptors of coastal environment. First descriptor is circulation or flushing patterns. The applicant has applied and received a water quality certification from DEM. In addition, while slowdown and increased turbidity is expected to be seen at the apex, the spacing provided and its overall size is unlikely to cause significant impacts. Sediment sediment deposits and erosion. While slowdown and increased turbidity is expected to be seen at the wave fence, with the spacing provided, it is unlikely to cause significant impacts. The shoreline is also hardened man-made structures, which require tremendous change in the environment for staff to consider the possibility of any impacts. This proposal lacks both the scope and the design to impact the shoreline. Impacts to biological communities, including vegetation, shellfish, fish resources, and wildlife habitat. This proposal is in line with current existing uses of the area. The area of the bay is not known for having any SCV or any aquatic habitats of particular concern. In addition, the staff reviewed past surveys, none of which showed any SCV as part of the bay. The proposal lacks both the scope and design to impact biological communities and any sufficient areas of historic and archaeological significance. The Rhode Island Historic Preservation and the Heritage Commission sent a letter saying, based upon the review to provide information, it is their conclusion this project will have no adverse effects upon historic resources. Scenic and/or recreational values. The applicant has chosen to use a low-profile vessel that has 14 inches of freeboard and no superstructures. That means the vessel will sit in visibility adjacent to other vessels in the marina. Water quality. In staff's determination, the pool boat wasn't considered an impact because there's no discharge. I'm sorry. In DEM's determination of their water quality standards they approved, the pool boat wasn't considered an impact because there's no discharge and no fill that's going to occur in the waters. Staff concurs with this assessment. Public access along the shore. Staff does not foresee any significant impacts. The vessel and accompanying activity will not significantly alter the activity already present in the area. There is also an adjacent ramp to the existing marina, which is not shown to cause any people transverse. Shoreline erosion, flood hazards. The shoreline is hardened man-made, which requires tremendous change in the environment. Staff consider the possibility of any erosion impacts. As previously mentioned, this proposal lacks both scope and design to impact the shores of this area of the bay. Evidence that the proposed activity alteration does not conform with state or newly adopted municipal development plans, ordinances, and regulations. Staff has determined this proposal is in line with the town of Bristol's 2016 comprehensive community plan. The plan the town outlines for the improvement to help recreation boating, call for Bristol to be a place providing people with economic opportunity through fishing, boating, recreation, aquacultural, biotechnology, and research. And the continued development and promotion of destination businesses, which this marina is considered a part of. It is in staff's recommendation that this matter does not rise to the contested case after reviewing the the criteria for what constitutes a substantive objection.
Any questions of Mr. Skinnion from the council at this point? All right, we've heard from CRMC staff. I think next, because we've got the threshold issue of whether or not the objections rise to the substantive level. Attorney Hartman, am I correct then that we'll hear from objectors solely as it relates to that issue and not full evidence with witnesses?
That's correct, Mr. Chair. And I can go to further detail.
If you could, please.
Yeah, so, Mr. Chair, I'm looking at 650 TAC RICR TAC 10 TAC 00 TAC 1.5.1 1F. This is in CRMC's management procedures. And this governs when a matter becomes a contested case. Specifically, that regulation says, in the event that during this 30-day public formal written 30-day public comment period, if I have to go back just a second, Mr. Chair, if you will let me. Essentially, a matter can become a contested case if a substantive objection, which is defined in the Red Book under section 1.1.6G. So it's a very specific definition. If that definition, if objections are submitted that meet that definition, then the matter can become a contested case. However, those objections have to be filed within the public notice period that's provided after the application is filed. So what that means is that an objection has to be filed within the public notice period. If that objection is substantive, it can make a matter a contested case. As a result, we are looking in the past right now. We're not looking at any evidence that might be put on tonight. We're looking at whether or not a substantive objection was filed within the public notice comment period. So the objectors can rely on the evidence they already submitted and make arguments as to why that evidence rises to the level of substantive objection, but they can't put on additional witnesses tonight to prove that that objection is substantive.
Okay. Any questions of Attorney Hartman from the council for full understanding? No. Okay. Attorney Hanley, I think what we'll do is we'll have the objectors come forward, state their objection. You will have an opportunity to speak, and then a staff will as well.
Chairman, members of the council, my name is Thomas Moses. I represent Stone Harbor Condominium Association in this matter. I don't know if you're aware, but the Superior Court Judge Landfair decided that in the Dumplings case, that any request for a hearing rises to the level to a need to have a hearing. That's absolutely clear in his decision, and I would add to what Mr. Hartman said about the judge's comment was that our request for a TRO wasn't right because you weren't given the opportunity to grant a hearing. The failure for you to grant the hearing would rise, and he expected to see us in court soon. So I just want to bring that forward to you. There were substantial objections submitted to CRMC on August 14th, 2024. There's letters from our firm, several letters from our firm. There are affidavits. Your file is full of documents from the applicants, not from the applicants, excuse me, from the objectors from Stone Harbor. There are additional issues that your council should be aware of, that this pool has other permitting requirements that have not been met, that are required by the Department of Health, which your staff should have required before you even considered this. Also, your definition of water dependency specifically does not include a pool as a water dependent activity. So if you read your own book, you'll see that there specifically identifies what water dependent activities are, and a pool is not a water dependent activity. If it was, I wouldn't have one in my backyard. Your definition says water dependent means activities and/or uses which can be only conducted on and over adjacent to tidal waters, coastal ponds, because the use requires access to the water for transportation, recreation, energy production, or source of water, and also non-water dependent activities that provide access to the shore to broad segments of the public. Now, that a pool does not meet that definition anyways. So I think we've met the requirements of the court. We've met the requirements of your regulations that a hearing should be provided in this case. I have other objections that I'd be happy to make if you go forward with your hearing.
Any questions of Attorney Moses from the council? Yes, Mr. Gagg.
Could you explain that dumplings precedent again, what you're basing?
Dumplings case is very clear. It says that if a request of a hearing is made, you shall grant them a hearing. That is what Judge Lanford has decided. Now, I know CRMC has appealed that decision to the Supreme Court. However, it is the law of the case right now until the Supreme Court acts, and they may fail to act. So you have numerous requests for a hearing in this. I'm at a loss of why you haven't granted them.
Mr. Gagnon, if I may address that. So in the dumplings case, and the council is correct that that is has been appealed by CRMC. The Superior Court did provide that a request for hearing alone under CRMC's management procedures rises an application to a contested case level. However, the way that the council has always interpreted the regulations, specifically what I referenced earlier, 1.5.1F, is that a request for hearing has to be substantiated by a genuine and material reason as outlined in section 1.1.6G of this title. There is a debate in the litigation about whether we rely on the definition section or section 1.5.1F. What legal counsel has said is that those sections are harmonious. And the fact of the matter is that a request for hearing has to be substantiated by a genuine and material reason to get us to a contested case. Now, what I would suggest is if the Superior Court agreed with counsel's argument, this would have been sent to a subcommittee already at the TRO level. We presented our opinion and our reading of section 1.5.1 to Judge McBurney last week, and he agreed that a request for hearing has to be substantiated by a genuine and material reason in order to get the matter to a contested case level. If he had not agreed with us, then there's a higher likelihood that he would have had good reason to actually mandate that the council send this to a subcommittee.
I have a question, if I may, because I just want to understand this fully. Am I correct that my understanding from what you originally said was that Judge McBurney said, I'm not granting TRO and mandating that it goes to a subcommittee because the council has not yet had an opportunity to hear the matter on their calendar?
Yes.
Okay. So now that we have the matter on our calendar, does that satisfy, and maybe you don't know this, but maybe you were there and maybe in his decision, does that now satisfy the part of his argument or decision that says that we did not yet have an opportunity to hear the matter? I get, I mean, I'm an attorney, I get where they go legal decisions in that. So was he basically saying, I can't make them send it down because they haven't even had it before them yet? Well, now we have it before us. And I just want to make sure because we try to do everything the right way up here. And if there's a legal mandate somewhere, I don't want to follow that. The legal mandate, as argued by Attorney Moses, was the prior decision from Judge Lanfair. But I know that's not final per se because there's more that's going somewhere else. And I think that Judge McBurney was aware of that. Judge McBurney knows about the Lanfair decision, obviously. And I would think that he took that into consideration when coming up with his decision.
Yes, that's correct. He was aware of the dumplings litigation. We had discussed it at hearing.
Okay, Mr. Chairman. Your own definition of contested case says a proceeding before the council shall be considered contested when a substantial formal written objection and or is the operative word here, request for hearing received by the council from any interested party. That is absolutely clear. You have a request from an interested party.
Can you address that?
Yes, Mr. Chair. So the section cited is section 1.1 of our management regulations, and that's the definition section. And the definition of contested case indeed says a proceeding before the council shall be considered contested when a substantive formal written objection and or request for hearing is received by the council from any interested party. The way that the council has long interpreted this regulation is that substantive modifies both formal written objection and request for hearing. So whether it's a formal written objection or a request for hearing, it must be substantive. And we have to look at section 1.5.1 in order to fully understand this, because 1.5.1F provides that substantive really means a genuine and material reason as outlined in 1.6G of the Red Book. And so we have to interpret substantive to attach to both request for hearing and formal written objection in order to read these two provisions harmoniously. And I'm going to read section 1.5.1F because it makes pretty clear that a request for hearing must be substantiated by a genuine and material reason in order for it to rise to the level of a contested case. Specifically, it says, in the event that during this 30-day period, formal written objection and or request for hearing is received by the Coastal Resources Management Council from an interested party, and said formal written objection and or request for hearing is substantiated by a genuine and material reason as outlined in 20 TAC 00 TAC 1.6 or 1.1.6G of this title. Therefore, the matter shall then become a contested case under the rules and regulations of the council. So section 1.5.1F directly says request for hearing is substantiated by genuine and material reason. That's how you get into contested case territory. This aligns with the definitions section, which you can apply substantive to the formal written objection or substantive to the formal request for hearing.
Mr. Chairman, look, I learned English in grammar school. That's not what that sentence says. You're making it up.
That's not
It's
true.
very clear. You may have interpreted it this way, and the council may have interpreted it, but the court clearly in Dumpling said, if a request is made for a hearing, you must grant a hearing. It shall be granted. That is not, they didn't say, well, let me think. If you deem that it's substantive, therefore now you can have a hearing. That is not what the court said. You're misinterpreting the court's decision in Dumpling, and you're over-reading the language that's in your own regulations. Well, now you may have read it that way, and other councils may have, but a judge has read this and has made a determination.
Understood, and a judge has also read it in the TRO hearing last
And
week.
you mischaracterized what the judge said. What the judge said.
Excuse me.
Going to hearing you from you.
I take offense to that.
You may take
Because
offense.
you're saying I'm misrepresenting what the court said, and I take offense to that.
Well, I'm sorry.
I'm not going to accept that.
I apologize for your offense, but the judge was expecting to hear from us right after this hearing, and we're prepared to be there. So I want to be clear with you about that. That was my understanding.
And excuse me, I was at the hearing
Yes, you were.
and I heard what the
And
judge
my
said.
partner was.
And I'll ask, were
Let's
you at
not
the
talk
hearing?
over each
I
other,
was.
please.
Okay, that I want to clarify that.
All right, I'm just replaying what my.
But you are saying that I misrepresented what the court said.
Yes.
Okay. Were you at the hearing?
No, I wasn't.
Okay.
But I have an extensive memo from my partner who was there, who does substantial work at Superior Court, and was clear that Judge McConnell was expecting to see us back.
Excuse me, I believe it was Judge McBurney.
I met McBurney, I apologize.
Anything else on this point before I have Attorney Handy come up?
No, I think.
Give him an opportunity to be heard.
Thank you, members of the council. I just want to address a couple of points. Generally, we're in accord with the staff recommendation and also with the position of council on this matter. But I want to just elaborate on some of the argument that we just heard. First of all, the three things that I heard as a basis for a substantive objection, one was DOH restrictions. Those are not relevant to the standards for a substantive objection at all. The next was whether it was a water dependent use or not. That is not relevant to the standards for a substantive objection, which your staff went through very clearly. I don't think I have to repeat those. The one that they did mention was water quality, and among other things, they've relied on the presence of submerged aquatic vegetation as part of their position on that. And the staff is clear and the council is clear that there is no submerged aquatic vegetation in the area of this application. This demonstrates just the reasoning for requiring substantive objections before delving into all of the cross-examination, all of the process associated with the hearing, because there should be merits to an objection before you require all the time and energy of this council and of the applicant and of the process to have a full-blown hearing with cross-examination of the witnesses. That's what the standards say. And I just want to back your counsel up in saying, first of all, it's important that you rely on your counsel. And so I'm a little bit reluctant even to add to what your counsel said, because you have a lawyer for a reason. You take the advice of your lawyer and what the law says, and that's appropriate. But I do want to say that, first of all, one thing that was made clear and I was at the hearing last week, unfortunately, I had to spend the morning in Superior Court as well. The judge said that, when there's an appeal pending in the Supreme Court, the Supreme Court specifically instructs them not to rely on Superior Court precedent that is up there that is subject to an appeal. It has not been decided whether that is the good law of the state yet. It is certainly not the law of this case as presented today. And I think your counsel presented good reasons why the management standards should be read the way he's suggesting. But there's another one. Why would you have a standard for a substantive objection that requires your staff to analyze 6 different factors if the other side could just request a hearing and get a hearing without meeting those standards? What good are the standards if you're not applying them in order to differentiate a contested case from an ordinary case? There are 3 different provisions in the management procedures that have to be read consistently. 1.5.1F is one that your counsel went into in great detail, which says specifically that it has to be a substantive objection to lead to a contested case. There's also the provision that we refer to in our filing, which gives the council discretion as to whether it wants to hear cases in the council meetings or at subcommittee if there's no substantive objection. If the council has that discretion, but they can request a hearing and overcome that discretion, it makes no sense. The council has discretion on cases that don't raise substantive objections. And the last one is this contested case provision, the definition of a contested case. And in that definition, as your counsel rightly says, the word substantive modifies both the request for a hearing and whether the objections are substantive. It's an adjective that is followed by two different events: an objection, filing of an objection, or a request for a hearing. And I think the only way to read all three of those provisions together consistently, which is what people that construe rules have to do, lawyers do, is to read them to require a substantive objection. That issue is on appeal. It's one of the issues that will be appealed to the Supreme Court. And unfortunately, you're in the position of having to make a decision on it when it's pending an appeal in the Supreme Court, but that's where we are today. So, I don't think I have anything more to present on these issues. Obviously, if we get to a hearing, we would love to have our engineer and our design professional address more of the substance of these issues as to whether they're substantive, and we can do that, but that's not what we're doing right now.
Thank you.
I'm happy to answer any questions.
Any questions of Attorney Handy? Do you have a question of our?
Yes, I need some clarification on what constitutes a substantive objection. And in relation to this case, there's a contention by the objectors that the staff reviewed this matter as a boat. Very simply. The objectors said, this isn't a boat, this is a structure. There's another section of the Red Book that you should have analyzed this application under. And I look at the definition of vessel and boat and try to determine whether this particular structure is contemplated by that statute. And I have a very difficult time trying to reconcile what that definition is and what this application is requesting. Now, is that a substantive objection? To me, it seems that it would be. Well, and to me, I think the most appropriate venue to determine that those objections and make those sorts of determinations is at a subcommittee meeting. It would be before the hearing.
Well, there are a couple points I can address there, Mr. Izzy. I'll start with your last one.
Okay.
So under our enabling statute, specifically 46-2320, it requires that all contested cases shall be heard by the administrative hearing officers or by subcommittees as provided in 46-23 Tac 20. The statute it's referencing essentially says it has to go before a hearing officer unless the chair or commissioner determine that the hearing officer is otherwise occupied, in which case it goes to a subcommittee. So that's to the first point.
Okay.
Primarily, it has to be the hearing officer. If the hearing officer is busy, it goes to a subcommittee. So that's the first point. As to substantive objections, I can't make a determination as to what's substantive or not. That's got to be up to the council. But I can go through the standard again, if that helps.
Well, if you can short circuit it and just respond to my, just call, you can call it a hypothetical. I mean, if an objector says, well, the staff interpreted parts of the Enabling Act and the Red Book, and we contend that they were wrong in that interpretation, and we have another very plausible, very reasonable interpretation of how the application should have been analyzed. Is that a substantive objection?
So I'll get as close as I can to that. So substantive objection I'm gonna do the one that's most relevant to your particular question.
Yes, I know, it doesn't have anything to do with, submerged aquatic vegetation or anything like that,
Right.
but it seems,
Well, no, there's
certainly is substantive. It may not come within the rubric of our regulations, but is it, are those exclusive?
so I think you're in the ballpark right here, because substantive objection can be defined as
Simple as I am.
direct evidence that the proposed alteration or activity does not meet all the policies, prerequisites, and standards contained in the applicable sections of the Red Book.
There you go.
So it's the council's determination, does the potential that perhaps another section applies, does that mean that it doesn't meet? Is that direct evidence that it doesn't meet all the policies of the Red Book?
Well, when appropriate, I'll make my pitch and make my argument and see if anybody agrees with it.
Absolutely. So, and again, this is I think that it can get a little bit complex with the different, definitions that we keep arguing about. But again, it's request for hearing or substantive objection, formal written objection that's determined to be substantive under the regs. And that's one of the things that you can look at, is whether it's
Comports with the
right.
Red Book. And
Does that make the request for hearing or the formal written objection, does that make it substantive, whether it complies with those standards?
All right, well, that makes me more comfortable. Thank you.
It's Mr. Flynn.
Isn't there a level of subjectivity in the determination of what is substantive? To me, it does not seem like it's black and white. As much as the regulations might try to provide guidance, the way Justin looks at something may be different than the way other reasonable people could look at something. And I'm not disputing his contention. But could reasonable people differ as to what is substantive? And that being the case, what then would be the harm of the matter going to subcommittee? Other than, I'm not even sure if it would add more delay, because I think no matter what happens here, we're going to have delay.
And Mr. Flynn, that's exactly right. Because what the definition of substantive objection is asking is whether there's evidence that's presented. So it's a question of your view of the evidence. Does the evidence rise to a level that gets you to a substantive objection? Evidence that the objectors submitted during the public notice period, does that rise to the level to get you to show?
And it doesn't mean you have to agree with that evidence, but could you at least acknowledge that it's substantive?
That's exactly right.
Any other questions? The council,
It's a rather subjective observation. I think he makes a good point. And erring on the side of caution, would we not think about referring it to a subcommittee?
Well, I think that's the determination the council has to make.
will that vote now? It seems like that's.
I mean, I think we heard both sides, and maybe have Justin.
Okay. Mrs. Scanlon, based upon, well, I'm not gonna say based upon, taking into consideration the arguments from Attorney Moses as well as Attorney Handy, is there anything you would like to add to your findings and opinion?
Yes, I would like to add quite a bit, actually. So this is an application for a marina perimeter limit expansion to accommodate a registered business. That's ultimately what staff reviewed. That's ultimately what staff considered. So I've already 10 questions about why did staff consider this a vessel, which was brought up by some objectors. staff follows the state definition of what a vessel is. That's what our regulations are, that's what it is, this will become registered. So the state has acknowledged that this will be a registered vessel. In determine. It was also brought up that this does not meet a water dependent activity. Marinas housing slips, housing vessels is by staff's definition, by CRMC's definition, a marina dependent activity. And we were also, there was an acknowledgement by Thomas that I may have missed something in my report about the Department of Health questioning the boat. We do not determine as an agency or staff vessels based upon marina slips based upon individual vessels. That is to say, if a ship sinks, gets retired, or gets sold, that slip does not become irrelevant. It is still, considered like part of the marina. So if there is like a fishing boat with a health violation, which is possible, it does not negate what has been determined to be needed by the marina or part of the permit. DEM did take a lot of look at the water quality, just to hit on ASAV and water quality again. Pilings being driven into this area is not, we don't consider that a water quality impact. If so, all marinas in the area would be a violation of various things. There's no SCV in Bristol Harbor. And I just want to say, from my perspective, in reviewing this, we talked about subjectivity. I received from objectors not as much evidence in an objective sense. If there was if you have a corner of your neighborhood that's prone to car accidents, usually when determining if there needs to be a guardrail up, there's a laundry list of incidents that you can present for why the town should consider guardrails. One of the questions we brought up was safety, and I did not ever get a list of possible boating accidents or anything of that nature. So while it is ultimately subjective to staff's determination of what determines to cross the line for substantive, if there was more stuff to bring to the council's attention in terms of evidence, that stuff is just in very little amount.
Any questions of Justin?
So I have one. I'm looking at this as as you mentioned, a marina expansion for a vessel. I don't care what kind of vessel it is. That doesn't really affect us in many ways, in my opinion. This is for a vessel to be used, whether it be a pool, a barge, or whatever. Am I correct in that understanding?
That's correct.
Thank you.
Also, barges count as vessels.
That's why, yeah. So I didn't mean to,
No,
delineate. It's for a vessel to go into that, correct?
that's correct.
Thank you.
I just want to note the definition of vessel. It means the statutory definition means every description of watercraft other than a seaplane on water used or capable of being used as a means of transportation on water, and shall include barges and tugs. Now, when I see a pool cruising along Bristol Harbor, that's when I'll determine that it's a vessel. But I think there's a difference of opinion, and it's a legitimate difference of opinion. And that rises to the level of substantive objection. I may not think a floating pool is a vessel. Other people may think it is. That's why we have a hearing officer or a subcommittee if the hearing officer is busy. That's how I see it.
I have a question of our council. Should this go to a vote as it relates to sending it to a subcommittee? Is it necessary that a council member makes their vote predicated on their agreement that the objections rise to a substantive level? Or can they just vote yes to send it there under the or section of that where it says 4 or more?
Well, in this instance, I think that there is a threshold issue of whether this is a contested case. So that determination has to be made.
Devil's advocate, why?
Well,
I mean, if we had no discussion this evening after Justin, and there was a 4-member vote to send it to subcommittee, goes to subcommittee without even addressing the whether or not the objections rise to a degree of being substantive or that it's a contested case. And I say that because I see, you can see maybe a little bit more needs to be addressed, digested, thought about, or whatever before a decision is made, at least for me. If an objection is substantive or not, but I think I'm under my right to just say, should I do that? I vote to send it to a subcommittee because under the statute or the ordinance, rules regulation, that 4 or more can do that.
well, Mr. Chair, on reviewing section 1.5.3A of CRMC's management procedures, it does in fact say a subcommittee hearing shall be required when a substantive objection is received from any party or when requested by members a vote of 4 or more of the Coastal Resource Management Council. So it does result in the same process. You get a hearing if the council, even if the council doesn't necessarily rule on whether or not it is a substantive objection,
Yep.
you still get a hearing.
I understand that, but we don't have to predicate our vote on a finding that we agree or not agree that it's substantive.
That's correct
Okay.
under that section.
Okay, any questions? Is there a motion at this point as it relates to referring to a subcommittee?
Mr. Chairman, at this time, based on the staff reports and argument council discussion with our council, I would move at this time to refer this matter to the hearing officer, and if the hearing officer is otherwise engaged, to a subcommittee.
Mr. Chair, if I may make one tweak, if that's going to be seconded, just that it's the chairman or the commissioner. In absence of the chairman, the commissioner can make the determination that the hearing is otherwise occupied.
Yes, with that modification.
Thank you. Is there a second?
Second.
Who seconded it? Seconded by Dr. Ruder, and I saw Mr. Russolino put his hand up as well. So motions are made. Is there any discussion? I'll now poll the council. Mr. Flynn.
Aye.
Mr. Izzy.
Aye.
Mr. Russolino. Dr. Ruder.
Aye.
Mr. Gagnon.
Aye.
Ms. Reynolds.
Aye.
I too vote aye for the reasons that I had enumerated in my questions to our council. So the matter will be referred to a subcommittee.
Motion to adjourn.
Yeah, having nothing further to come before us, I have the motion to adjourn, which has been made by member Russolino. Is there a second? Second. Seconded. All in favor, say aye. Aye. No one opposed. Motion carries. Good job.